Silence. I'll call this workshop to order. In accordance with the town's procedure bylaw, no decisions are to be made, but rather this meeting is an opportunity for council to have an informal discussion regarding various matters. The discussion for today, of course, will be our strategic properties, and we'll start off with a PowerPoint presentation. Mr. Shelton, did you want us to lead us into the discussion?
Thank you, Mr. Mayor. This is a workshop that we've proposed for a couple of months now, and our Director of Legal Services will do a brief introduction, and then we'll get right into it with the open portion of the meeting and then the closed portion of the meeting dealing with property issues. So I'll turn it over to Esther.
Before we do that, I should request if there are any declarations of pecuniary interest. Being none, we'll go forward then. Go ahead.
Thank you, Mr. Mayor. Good morning, Mr. Mayor, members of council, staff, and members of the public. Today's workshop is going to provide you with an update on a number of strategic properties, and we are going to have both an open and closed session to this workshop. First of all, we're going to just provide you with a very brief high-level overview of the town's legislative authority. It's more for a refresher and the legislative authority to deal with the acquisition and disposition of land. We will provide you with some of the background and framework for the strategic property and the initiatives that have been undertaken. And we will also report on some of the matters that have been completed. We will then move into a closed session to provide some more detailed background regarding council direction previously received in closed session, as well as updates on the status of staff negotiations and discussions around some of the key properties that we've been involved in. So given the limited time for this presentation, this is just meant to be a high-level overview. And on the roadmap, which is the next page of the presentation, we just talked briefly about the legislative background and overview, our background on strategic properties, and those matters that have been completed. So just by way, again, as a refresher for members of council and for members of the public, Section 270 of the Municipal Act is our guiding authority. It requires every municipality to adopt a policy regarding the sale and disposition of land. The town is a large landowner, and municipal property is comprised of lands for a number of municipal purposes. So they include highways, parks, recreation, cultural and entertainment facilities, municipal offices and operations, trails, open spaces, wetlands, wastewater facilities, and the like. Municipalities are a creature of statute under the Municipal Act and are given very broad powers for the purpose of providing good government with respect to matters within their jurisdiction. And the Municipal Act was amended in 2001 to enhance the tools that we have to provide broader and more flexible powers to govern our affairs and to enhance the municipality's ability to respond to municipal issues. So like a natural person, a municipality is entitled to acquire and dispose of land. So Section 270 of the Municipal Act requires municipalities to adopt and maintain policies with respect to the sale and other disposition of land. So the purpose behind that legislative requirement is to inform the public of any proposed sale before the municipality binds itself to sell the land. It's intended to enhance the principles of transparency and openness. However, it doesn't mean that a municipality is required to provide details of negotiations that are ongoing. The reason is because that kind of information could compromise the integrity of the sale process and might result in a claim for bad faith against the municipality. If so, and it could impact future negotiations. So those things, for that reason, are kept confidential and are discussed until direction is given to proceed in a certain matter, and that direction is implemented. So the town has a sale of land policy, and this policy was updated in 2013. So the new policy aligns with Section 270 of the Municipal Act. It establishes a consistent, transparent, and accountable procedure to be followed in the disposition of real property by the town. And it also gives the town flexibility to deal with different properties in a different manner, such as flexibility in determining the price. So the policy generally provides that prior to any disposition of lands, the following actions need to occur. First of all, the lands have to be declared surplus by council. Second, there needs to be at least one appraisal. Third, the method of disposing of the land is generally one that is approved by council. And fourth, notice of the proposed disposition is given to the public. So in terms of acquisition of land, the need for land and property is often identified when determining the overall needs for infrastructure projects or service locations, or enhancing and extending the town's inventory of parks and open space. The town doesn't have a dedicated policy that deals with the acquisition of land. However, over the past number of years, council has adopted a roadmap that identifies and prioritizes property acquisition in the context of the town's official plan, parks needs studies, existing policies, and the completion of the Viva project. So sometimes opportunities to acquire real property are presented to the town through an unsolicited offer, through negotiations with a developer, or through other levels of government or agencies, such as the province of Ontario, the region, and Newmarket Tay Power. These opportunities to purchase may be made in advance of the town having identified a particular use for the lands. But in all cases of land acquisition, the town is guided by the delegation bylaw, and council is the ultimate approval authority for any acquisitions, except for minor acquisitions relating to road widenings and approved capital projects through the town's budget, in which case usually the Chief Administrative Officer and the Commissioner of Development and Infrastructure Services are the approval authority. So our lease and license agreements, briefly, are again captured under the delegation bylaw. Rent must be at fair market value, and the terms and conditions of all leases must be reviewed and approved by the lead department and by legal services. Signatories for agreements of purchase and sale. Once council has authorized either a disposition or acquisition of land, agreements are typically authorized by the Chief Administrative Officer and or the Commissioner of the lead department, and the delegation bylaw identifies who else is required to sign the agreement, and the legal services department ultimately handles the real estate transactions internally unless the matter is urgent or unusually complicated, in which case we may retain external counsel to perform some of that work. And I just wanted to mention about the official plan requirements for acquisitions of land. The town's official plan contains comprehensive environmental requirements prior to the acquisition of land. So these requirements generally include completion of a Phase 1 environmental site assessment, when the acquisition results in a change of use to a more sensitive use, where a Phase 1 environmental site assessment reveals that there may be contaminants on site due to a previous use of the property, then a Phase 2 environmental site assessment must be conducted under the Ministry of the Environment regulations. And a record of site condition may have to be filed with the ministry. So the record of site condition demonstrates to the ministry that the property is suitable for the proposed use by meeting the soil, groundwater, and sediment standards for use. I just wanted to mention to you, when I was talking about Council's roadmap for the acquisition of lands, this roadmap has recognized that the town has undertaken land acquisition, planning, analysis, and securement on a number of occasions, and I'll just give you two examples. One is when the town identified a need for a second recreation facility and undertook a process that concluded with the purchase of the 90-acre Stickwood Walker Farm and the creation and implementation of a development plan for the recreation center and the open space. There's also historical preservation involved in that plan and residential development. So another example was the identification of a proper site for the town's operations center. So again, a study and site search culminated in the acquisition of lands off Harry Walker Parkway on Maple Hill Court and the subsequent construction and completion of that facility in 2016. And together with that, the town was able to successfully dispose of and sell the former Parks shop on Eagle Street. So at this point, I would like to turn your attention to three matters that have been concluded, and I'm going to pass the torch now to Antoinette Mollicone, and I also wanted to thank Antoinette, who has done just a tremendous amount of work to update this presentation for you today. And I also wanted to thank Tanya, who is here, who is, her and her team have spent a great deal of time trying to get this easily accessible for us to see in maps. So thank you very much.
Thank you. Good morning. We will open up our discussion with respect to completed property matters, and three that I'm happy to report have been completed late last year and early this year have been portions of 230 Davis Drive, 44 Isaacson Crescent in Aurora, and thirdly, Lydia Street, portion of Lydia Street. So with respect to the 230 Davis Drive, that is the Church of Christ property. And over the past few years, this property has been the subject of several reports to council regarding the acquisition of this property. And in September of 2014, council directed staff to negotiate and finalize the agreement for the purchase of the portions of the property set out on the slide as parts 1, 2, and 3. And in July of 2015, an agreement of purchase and sale for these parts was finalized with the owner of the property on February 12th. The agreement was completed on the following terms. Parts 1 and 2 were purchased for a purchase price of $500,000. Part 3 was donated to the town in exchange for a tax receipt and recognition plaque. Part 1 was acquired for a future road allowance. Part 2 was acquired for a trail connection, eventually linking the community to the south. Part 3 was acquired for community breathing space, open to Davis Drive with the foregoing trail connection to the south. And the breathing space is meant to provide an attractive street presence on Davis Drive in this location and an inviting entrance to the proposed trail. Although the designs for the area are still in its inception stage, the space would include a seating and gathering area with benches, open paving, a placemaking feature or focal point, and green space with a planted backdrop. Another property that was completed early this year was 44 Isaacson Street in Aurora, and these are the future fire hall lands. Central York Fire Services serves the towns of Aurora and Newmarket and operates under the direction of the Joint Council Committee. which provides and administers a borderless single tier of fire protection and prevention services throughout both towns. In January of 2016, both councils of Aurora and Newmarket authorized the purchase of these lands for a 6th fire hall at a purchase price of $3,690,000, with 59.8% to be funded by Newmarket and 40.2% to be funded by Aurora. The transaction was completed on February 12th of this year, with joint ownership of the property by Newmarket and Aurora being reflected on title in these respective percentages. So the total cost for Newmarket in this purchase was $2,240,877, and of that sum, the purchase price was $202,206,620,000. That included land. That initial amount included land transfer tax and disbursements and legal fees. The next property that was completed was the sale of a portion of Lydia Street, which is the portion that's east of Muriel Street. And in June of 2015, pursuant to a staff report and recommendations, Council declared the parcel of land surplus to municipal needs and directed staff to undertake the necessary processes to permanently close the land, list the property for sale, and enter into discussions with parties interested in purchasing the lands. In accordance with the town sale of land and notice policies, the requisite public notice of the town's intention to declare surplus, permanently close, and sell the Lydia Street lands were published. And the property was listed for sale with the town's listing agent on the MLS. And in September of 2015, Council passed a bylaw to permanently close the lands. And the town also sent notices to adjoining landowners for expressions of interest to purchase the property. Only one offer was received by the town within the offer submission period, which was for $250,000. And in accordance with Council's direction of October of 2015, staff negotiated and finalized the agreement of purchase and sale between the property, between the town and the proposed purchaser, for $250,000 on an as-is basis. In addition, a further public notice of the proposed disposition was published in accordance with the town's sale of land policy, and the transaction was completed on December 18, 2015. The net proceeds realized by the town sale was approximately $225,000. As well, a staff information report to council, which was posted on the town's website, addressed some drainage concerns of some owners of the neighboring properties. As the report indicated, engineering staff concluded that any drainage issues affecting the Lydia Street lands would be adequately addressed through the town's property standards bylaw and the site plan approval process in the event of a potential development of the Lydia Street lands. And this was communicated to the concerned residents.
Okay, so before we go forward with the closed session, could I have a motion then, please? Are there any questions with respect to these items before we go into a closed session? Okay, I'll entertain a motion then to go into a closed session to discuss the proposed and pending acquisition or disposition of land by the municipality as per Section 2392 of the Municipal Act. Councillor Vague, Councillor Hempel, all those in favor? That is carried. What we better do is make sure that our screen is shut off.
Oops.
Linda can do it.